you can, you won't, and you don't stop. Or when you can, you won't, and you don't stop. Might be coming out for sure.
Imagine that we have agreement. The next element that we need to get a simple apparent contract is intent. What we mean by intent is that the parties who agreed actually intended there to be legal consequences that went along with that agreement. If there's no intent, then there can't be a contract. Okay, so you have to have intent. Hopefully, it's relatively simple, particularly in business. But because it involves a little bit of legal thinking and a couple of way legal tests work, we're going to use some old school approaches to intent and then let you know what the actual true legal situation is. But we'll be using the old school legal test for it to help us with some of those legal logic kinds of skills that we're trying to develop. Okay, so let's get into intent. Now, not every kind of agreement is actually a contract. You know, if I agree to meet you down the port office for a beer and I don't turn up, you probably can't sue me, right? We have agreement, but we never had intent to create legal relations. We could argue there's consideration. You know, I'm giving you my company, you're giving me yours, but we really can't kind of argue that there's intent. Most people don't expect to be sued for not turning up to the pub to meet someone who they agreed to. So the courts want to distinguish those situations where we just have an agreement or even a promise from a contract. One of the ways it does that is, what did you intend? Did you intend there to be legal consequences? Now, the way the courts look at that in the modern era is they look at it at the outside from an objective observer. What would an objective observer think about this agreement? Was there an intent to create legal relations, or was there not? This modern approach developed based upon a long history of common law to a new style of test that really works roughly the same way the old test did. But because a lot of things have changed in the world, the old test had a couple of wrinkles around it, which I won't bother you with. They were very old areas of law. For instance, the common law used to believe that if you were employed by a church, you actually kind of didn't report to anyone in the church. You're employed by God. So that led to some difficult contract situations in the modern era. So that's why they've moved to the more objective test that we'll see at the end. But the roots of that test come back to the early common law development. And there are two key cases I'd like to look at, because these two cases give us the two core situations that we deal with: social, domestic or voluntary, or business. So let's have a look. Now, I don't think it's exceptionally important that we understand the distinguishing facts behind these two cases, just the principle of law that comes from them. For a bit of colour, in Balfour and Balfour, you had this guy from England who was sent out to Sri Lanka, or Ceylon as it was in the day, where he was an official, right, in Ceylon, and that's how he made his living. He got married, had a wife. They went back to England on holiday. So they went back to England on holiday, and the wife really didn't like living away from England, so she stayed, right? So the wife stayed, and the husband went back to Ceylon. When he came back, he said he was going to send her a certain amount of money. I think it was £30 at the time, in order to give her money to live. Then he stopped paying the money, and it broke down, etc. And the wife was saying, well, this was a contract, right? You agreed, we had an agreement that you would pay me that amount. And the courts looked at that and said, yeah, you did have an agreement, but does a husband or wife intend to be legally bound when they make an agreement with their partner? Right, with your friends, in that kind of situation, do you intend to be legally bound? And so they came up with this idea, this principle, that there is a presumption. Let's be very clear. It's a presumption. It's not absolute, but it's a presumption that in social or domestic just means kind of household husband, wife, two partners, social, domestic, or voluntary situations, you do not intend to be legally bound. And so therefore, in this case, there was no contract. In contrast to that, in the case of Edwards and Skyways, there was an agreement between two parties in business. It had to do with union negotiation. It was quite complicated, so I won't go into the details. The key principle, though, is that there is a presumption in business. If you're in business, that you do intend. Okay? So they're our authorities. Edwards and Skyways, the presumption in business is you do intend. Balfour and Balfour, the presumption in social, domestic, or voluntary situations is you do not intend to be legally bound. So, where the agreement is made in a social or domestic context, it's presumed that you weren't intending to be legally bound. Where it's made in a commercial or business context, it's presumed that you did intend to be legally bound. However, these are only presumptions that can be rebutted. Now, it's very hard to rebut the business one. So we're not going to go into that. You need specific words if it's the business setting. But you can rebut in social situations. So the two classic cases that we have, well, they're two of many. A common one is Trevi and Grubb. Trevi and Grubb was a group of friends who bought tickets in the lottery. The lottery ticket won, and the person who won the ticket tried to take all the money and say, well, it wasn't a contract with my friends, it's just an agreement, so I don't have to give them the money. Court said, no. The consequences were so significant, winning a large amount of money, that this rebuts the presumption, right? So given the whole point was that you would win and share the money, and that this has a large impact on your life, of course you intended to be legally bound by this agreement to buy the ticket. So that's an example of the rebuttal of the presumption. Merit and merit is a similar one, right? You have a husband and wife. They were constantly separating, or they'd separated several times. At one point they've separated, and the husband wants the wife to come back, and she agrees to come back provided he puts half the house in her name. She comes back, they fight again, she leaves, she wants her half of the house that he never put in her name. Okay. He tries to say social domestic relationship, social domestic agreement, it's not contractually binding. I don't have to put half the house in my wife's name. The court said, no. This is a different situation, right? Why? When you're separated, which is when they agreed, it's a different context, right? And half the house is a large amount of money with a big impact on your life. So when we look at this situation, we'd say the presumption that you didn't intend to be legally bound is rebutted, right? And so he did have to transfer half the house to the wife's name. Very different to Balfour and Balfour, right? They were together. It was a social domestic relationship about spreading the money in the marriage. In this one, the marriage is kind of broken down, and there's an agreement outside that. So you have to look at a lot of factors. How big is the decision? Did they get kind of lawyers involved? What would a person really expect in that situation? And out of that, we've got the test that currently is being laid down by the High Court in the homogenous case. So the courts now actually look at the conduct of the parties, what they said, what they did, any documentation. Okay. If we're dealing with business rather than social and domestic, we need to be very careful when we do things like letters of intent and letters of comfort. These are things that people put in place around debts, etc., and they can have legal consequences. We want you, in this subject, to use the traditional presumption approach and become familiar with the way a presumption and rebuttal works in law. Okay, so that's intent. So we've got agreement, we've got intent. We now just need consideration. If we've got consideration, then we've got a simple apparent contract.